of a reasonably competent physician or similar circumstances. So we have a certain duty, and that has to be provided with a proper standard of care with due skill. So dereliction or failure to fulfill a duty, that means we have deviated from the duty what we should have, which we are ought to provide to the patient. So this is one of the difficult and more resource intensive parts of a medical negligence case in proving a physician breached their duty of care. The plaintiff means the patient or the litigant, he needs to prove any reasonable doctor in that situation would not have acted the same way. Then the doctor failed to act in accordance with the best practices for their field. So there are certain protocols and the literature. We have to follow those best practices to say that we did or we provided such a management to the patient which an equally qualified person would have provided. Then a doctor of the same field in the same circumstances would have done it differently. That is commonly dereliction or failure, breach of duty. The third is the damages, which is the most important. It refers to the quantifiable amount that a patient has lost due to the medical negligence. So evidence of damages usually include the test, prescription records, medical records, testimony of an expert witness, your own testimony. Damages could be quantifiable or even physical infirmity or anything else. And finally, the direct causation, which actually has a relationship between dereliction and the damages. It is a fourth element and is the second most contested element of medical negligence. So direct cause can sometimes be difficult due to complicity of medicines and finger pointing. Now we come to again 4 common concepts applied by the court of law in negligence. Let me again remind you that we are talking about how to avoid litigations, and these 4 common concepts again are followed by the court of law. Case of alleged medical negligence comes to their court. So these 4 are res ipsa liquiter, you might have heard about it, contributory negligence, Boehm's principle, and vicarious liability. So what is res ipsa liquiter? It is basically in general terms, facts speak for themselves, and the negligence is so obvious that a complainant need not prove anything. For example, surgery on a wrong part, wrong patient or the wrong side, leaving an instrument, swab pad, etc. while operating, then causing burn to a newborn baby from hot water bottles or through the radiant warmers, wrong blood group transfusion. So all these are, the negligence is very obvious, and all these cases end up being judged against doctors, most of them. So contributing when the patient's relatives, parents, or the patient himself contributed to the adverse outcomes leading to some damage or thing, like not coming for follow-up, failure to follow instructions, acting against medical advice, consent not given, investigations not done. Now, let me be very clear that all these, any kind of emergency situations do not warrant all these contested points. And then failure to consult a specialist, left against medical advice. So in contributory negligence are implementation, wherein we can or repeatedly advised to the patient and the patients didn't follow that. Let's say a patient came to us and we advised him certain investigations. He didn't do it, citing whatever reasons. Then second, on third day, again, he came for follow-up. You again feel that the investigation should be done. And but then you should not verbally say it. You should actually write it again so that it becomes an evidence later on. If at all something happens, the patient will point, because he would simply end up saying, which is what happens, that the doctor never advised me. So your documentation is your defense, and we should not forget it. Then one very important law used all over the world is again Boehm's principle since 1950s. So it says that if there are 2 methods of treatment, a doctor can choose one over another. So mere adverse outcome doesn't make the alternative method a better choice. For example, anterior versus posterior approach for adenoidal tumors, or one antibiotic versus the other antibiotic, so long the choice is reasonable. And to justify a criminal conviction, a doctor must have grossly breached or negligent to the standard of care, resulting in damage and death. And what is the standard of care? This is has been defined in various judgments, Bolam's principle, Suresh Gupta versus Government of NCT judgment in 2004, Jacob Matthews. So it says that the standard of care should be the standard of a reasonably skilled and experienced doctor in his particular field of medicine. So this is very important, and a lot many judgments you can surf the net, take this standard of care. We always talk about standard of care. So this is the standard of care which one should is supposed to offer to his patient. Then again, as I told, the same thing. So proper standards have to be taken care of. And this judgment was, as I told, was followed by the two landmark judgments of Suresh Gupta and two in a year later in Jacob Matthews judgment. And the Honorable Supreme Court made the following observation, that a professional may be held liable for negligence when he didn't possess the requisite skill which he professed to have possessed, and or he did not exercise with reasonable competence in the given case the skill which he did possess. These are very clear, and these always come as a defense in our litigations or alleged cases of negligence. Now, very important is vicarious liability, wherein any of part of your team, anyone like a hospital staff, partners, locums, associates, can be held vicariously liable for the negligent act of other. So, for example, if a wrong blood group transfusion or a wrong injection has been given by the duty doctor or the staff, then the whole team is doesn't mean that the head or the hospital is not vicariously liable. So this is important, and it is taken care of in so many judgments. Let's say there was a case of res ipsa loquitur, wherein a swab or a instrument has been left in the abdomen by the whole team. So the whole team takes care of it, and the patient can go also against the hospital, citing vicarious liability. And Supreme Court and the National Consumer Forum have clearly given the judgments in this case way back in 2019. And they clearly say that a doctor is vicariously liable for the act of its team members. So we should never forget it. And now we come to the backbone of proper preventing of any kind of medical legal litigations. And these appear very simple, which we lack nowadays. First is the good communication and proper documentation. And these are the main bridge avoids any kind of medical legal litigations. And as we all know that from whom to whom we communicate. And so in brief, how do we label a patient-doctor communication? It is a verbal and a non-verbal process through which a doctor obtains and shares information with the patient, thereby developing a therapeutic relationship. So this is a general term. A communication can be verbal and non-verbal. Non-verbal includes our body language, listening skills, how our eye contact, and all of the how we are dressed, and everything. So primarily in communication, emphasis lies upon the spoken word, since more than 70% of all the communication efforts are either misunderstood, misinterpreted, rejected, disliked, or distorted, or even not heard, even in the same language and same culture. And so most complaints in the healthcare system, both public and private, arise from poor communication. It is clear that communication forms the building block of a good doctor-patient relationship. And this, whether we like it or not, but nowadays the communication has totally taken a back seat, and the patient doesn't perceive it nicely. So besides this verbal communication, we definitely should have an art of listening. And only if we talk about the biological standpoint of view, we know that we were created with 2 ears and 1 mouth. And so the implication, of course, is that we should hear twice and we should speak once. Now, what are the advantages of a good communication? More time with the patients, higher patient satisfaction, adherence to long-term therapy, results in better care and improved treatment outcomes. It also saves money on unnecessary interventions, prevents avoidable misdiagnosis, mistreatments, and misunderstandings, less chances of further complaints. And most complaints, as we told, are because of communication. and it forms a good building block of the good doctor-patient relationship. Now, another most important is the documentation. So documentation is your evidence, and we should document whatever, be it negative consent, be it all the notes with proper dates, time, signature in a good readable handwriting. Then we should mention all the review advice. We should mention any allergies. We should even ask in our history on our OPD slips that suggest that we actually asked and know any allergies or not. We also end up knowing some kind of drug related or some food allergy, which patients end up telling if we have asked about it. Then any kind of discharge against medical advice. It doesn't mean that we don't offer them a discharge. It is a full discharge summary, but duly consent and signed by the patient or two independent witnesses, or the only thing is it is labeled as discharge against medical advice. Then adverse outcome and hindrance in detail and referral notes. So why is documentation important? From the legal perspective, documentation is your evidence. So if you have seen a patient 10 times in a day, but you have documented only two times in your IPD sheets, then it will be only counted at twice. So we should document each and everything. Even if the patient has refused any procedure, you should document it. Maybe he agrees to it tomorrow, but in today's date, you should refuse. You should just document it clearly that the patient refused and the implications have been told, unless it is an emergency procedure. So emergency situation is the only situation wherein the court takes your point of view as a good point of view, if at all you are able to prove it. So how will you prove it? With or the patient parties use it to prove that the standard of care was breached. Example, someone administered the wrong dose of medicine, and the defendants, that is we doctors, use it to prove that the standard of care was met, and that is the care that was required to be provided was provided. And this is the best defense of doctors in medical negligence cases. So in just a short overview of the display, your display board or the notice board should have proper instructions, degrees, medical council registration as per MCI norms, then display all your certificates. CCTVs should be mnemonic is fast, they should be functioning, adequate in number, strategically placed, ensuring the patient's privacy and time properly. That it should also declare that the premises are under CCTV surveillance, and you should also declare your fees or procedures for this thing. Now, very important thing is the medical records. So there are so many schools of thought, but on an average, all indoor records should be preserved at least till minimum 3 years. Then for patients, 3 years after the patient attains adulthood. So this is a gross. So let's say, for example, a child is 6 years old, and so we need to preserve it 6 plus. So by 18, after 18 years, he will attain maturity. So 6 plus 12 and 15 years, 6 plus 15 years. So till he grows out to be a 21 years old, we should actually preserve the records. So a reasonable safe state policy is OPD records 5 years. Usually it is also said 3 years, but 5 years is a good time, reasonable time. Indoor 15 years, and medical legal cases maybe through lifetime. And we are actually supposed to provide the records within 72 hours on receiving a notice or to any authorized representative of the patient's attendance. So one more important part is the destruction of the records. So before the destruction of the records, you have to notify it officially in the print media that we are destroying such and such records from this year to this year. If a record, then he can take it, because the records are not only the hospital or the doctor's property, but they are also the patient's property. And it's the records only that save us. And definitely documentation errors, mislabeling, misspelling everything, or using of abbreviations like LP. Now LP could be lumbar pains as well, and lumbar puncture as well. So we need to take care of this, and the court has taken this thing into their cognizance n number of times, and legitimate handwriting is again an issue which should be taken care of. So digitalization of record, digitalization of your prescriptions definitely come into existence, which takes care of the writing part as well. So one more last important is consent, whether consent is a contract So the question is there. So there, a consent is an act of reasoning and the deliberations made. So it should be a proper knowledge. There are certain gray areas whether pre-printed forms or this thing should be there. But yes, definitely, if we have got a pre-printed form of a specific procedure highlighting the specific complications and everything about that these are taken into consideration. Or maybe a local IMA or the local bodies can universally use a same printed form which covers all the varied parts duly signed by the patient and the attendant and two witnesses, and that is taken as a good consent form. So it can be implied, blanket, informed, or written, and sometimes one can exceed the consent. And always in our medical practice, we need to know about the exceptions, maybe an emergency or court order or public interest, wherein consent cannot be given unless it is a life-saving procedure. So what is a consent? It is understanding the patient of condition or nature of illness, purpose and nature of procedure or treatment proposed, treatment or procedure, risk and benefit of alternative treatments or procedures, prospect of success or failure, that is the prognosis in the absence of intervention, and acceptance or refusal, informed refusal of the SAND procedure or intervention. Vernacular language, it should be there in the vernacular language, means the patient understands, or if at all he is able to write in his own language, or else we should use some interpreter for the same. And to end with, we should definitely have a professional indemnity insurance. Nowadays, the district forums pecuniary jurisdiction is almost runs in crores. So we need to take care of it. And indemnity means to make good the loss sustained by the insurer. So professional indemnity insurance for doctors is a liability insurance for doctors that provides cover against professional risk to pay for the damages arising out of negligence. So what I suggest is a common a patient who has at least an insurance of 2 crores at least, and for its establishment separately as well. And in the end, I would mention 3 of the most important Supreme Court historic judgments, which are landmark judgments and favorable judgments for the doctors, and always come into while defending our cases. First is the Dr. Suresh Gupta versus Government of NCT in 2004, which actually highlighted about the criminal importance liability of doctors. So criminal liability on a high pedestal and required the medical negligence to be gross or reckless. And it said that mere lack of necessary care, attention, or skill, error of judgment was observed to be insufficient to hold one criminally liable for negligence. It was observed that mere inadvertence or simply a want of certain degree of care might create civil liability, but will not be sufficient to attract criminal liability. And in Jacob Matthew judgment, 2005, the Honorable Supreme Court ruled that doctors should not be held criminally responsible unless there is a prima facie evidence before the court in the form of a credible opinion from another competent doctor. Herein, it could be in Delhi, it's Delhi Medical Council or the negligence boards in other states, preferably a government doctor in the same field of medicine, supporting the charges of rash and negligent act. So it is a laudable judgment in the light of criminal procedures filed against the doctors in the era of IPCs, where prima facie there seems to be no neglect in these medical treatments. And directly or indirectly, a lot of doctors have suffered, unfortunately. And so we need to then know these judgments. And the Jacob Matthew judgment also says that the police cannot arrest a doctor. So even if there is a supposed negligence, but unless it is proved, the police actually cannot arrest a doctor, and they're also liable for persecution. So it also practically absolves the medical portion of the liability of Section 304. It was used to be 304A, and in this case, the Honorable Court had gone through the details of the problems faced by the medical professionals, and this landmark judgment no longer distort the doctor-patient relationship and benefits the patient in the long run. And Martin D'Souza case again in 2000 versus Mohammed Ishfaq in 2009 again reiterated the fact of the Jacob Matthew case, and it again warned the police officials not to arrest or harass doctors. And otherwise, the policemen could themselves have faced legal action. So these are very important. Any case of proposed negligence, the police actually cannot arrest you, And we can hold the copies of these judgments in brief in our OPDs, and these can be taken care of in that kind of situation. And even the Haryana Legal Service Authority way back in 2018 told that police can't arrest doctors for medical negligence without initial probe. And it also highlighted that today the doctors try to save themselves out of fear in the hour of need, and better awareness of intricacies of law would help provide better treatment to patients and better compliance of law. So we know that healthcare is under attack, and the sanctity of healthcare, the right to health, and international humanitarian law are threatened. Such attacks deprive people of urgently needed care, endanger healthcare providers, and undermine healthcare systems. And even Lancet, way back in 2006, mentioned that we must protect patients, but we must also find better ways to protect professionals. If we do not, medical progress will cease, particularly in controversial and distressing areas. And as we should know that the selection of patient is an art, we should understand the red flags, and there is a stamp mnemonic which is globally taken care of, and this is श्लोक which says that श्रेष्ठ एवं विद्वान को चाहिए कि वह इन लक्षणों से युक्त योगियों की चिकित्सा नहीं करे. I must say that we should not take it as a but it can be taken as a preventive or a red flag sign. यथा स्वेच्छाचारी, मरणासन, इंद्रिय शक्ति से रहित, अपने शत्रु वैद्यों से द्वेष करने वाला, श्रद्धाहीन, वैद्य आयुर्वेद पर जिसकी श्रद्धा ही ना हो, शंकालु, हमेशा वैद्य औषध एवं परिजनों से सशंकित, तथा वैद्य की आज्ञा न मानने वाले रोगी की चिकित्सा नहीं करें. इनकी चिकित्सा करने पर वैद्य को अनेक प्रकार के लांछन दोष सहने पड़ सकते हैं, और रोग शांत न होने पर यशोहानि, अर्थहानि, वैद्य निंदा, अज्ञान, लोलुप आदि अनेक प्रकार के दोष लगते हैं. So this is a general term, and it's kind of prevention. We should always remember that, but it should not actually compromise the patient care and health, what we actually are supposed to do, what we are officially supposed to do. And in the end, take home, I'll say, please wake up wise, stand dignified, stay updated, have a safe practice, stand united, don't do medical jousting, love yourself, family, friends, and colleagues, have a healthy work-life balance, have a sound sleep, risk management strategies should be in place, and indemnify yourself. Revise and refilter your communication techniques, record completely, respect your colleagues, have a good rapport with the client, and try to provide a reasonable care to the patients and reasonable cost. Ultimately, the patients come with a certain trust in you, and we have to rebuild that trust for whatsoever reason which has been lost. And again, I'll end my presentation with the known term, which is prevention is better than cure. And these were certain preventive measures which we should follow in our day-to-day practice. And definitely we should, we are able to avoid litigations because of so many good documentation and communication in our day-to-day practice. We should also be a member of such organizations like Indian Medico-Legal and Ethics Association, which only talk about medico-legal. This is a quarterly journal of the organization. We also have textbook on medico-legal issues. The 3rd edition is in place by JP Publishers, and it takes care of all the specialties. You should all have this book along with you in your practice. And thank you for giving me this opportunity to make my views on this, especially IMA Haryana State, all the organizing and technical committee, and all the participants. Thank you. So I'm open for questions.
Thank you, Dr. Jain. It was a wonderful presentation, masterly presentation indeed. You almost covered all the topics, though it was a lengthy topic, but you covered it in a nice and a smart way. If anybody has any question, he can unmute himself and ask directly.
Dr. Pawan, just want to inform everybody that we are in the process of finalizing all the insurances, especially indemnity insurance with the Cover You. They are giving us a very good rates, and probably in a week or so we will be finalizing and we will be signing the MOU with them. And these are very competitive rates, and almost 40 to 50% of what the prevailing rates are there in the market. And I will request each of our colleague and all the members of IMA Haryana, and it is only for the IMA Haryana members. Even you have to write your membership number also. It is not for any other person, those competitive rates. So mind it that please enroll yourself for that, so that we can save money and we can get the good professional advice also from them. That is from my side. And thank you, Dr. Ashish Jain. It was wonderful presentation, and of course, it needs a lot other many discussions and classes. And before signing off, I will request Dr. Suresh Vasis and Dr. Pramod Kohli for very brief and crisp comments about the topic. And please, sir.
Dr. Vashish sir and Dr. Kohli sir. Sir, your comments. Dr. Kohli sir.
Dr. Ashish has covered the entire gamut of
Sir.
medico-legal issues. Am I audible?
Yes, sir.
Yes, sir.
Yeah. He has covered almost everything about medico-legal services. I would like to emphasize on the preventive aspects. One, of course, is that we should resort to ethical practice. Although we want to earn a lot of money, it's prudent on the part of the doctors to take up less number of patients, charge them well, but spend time with the patients. Many a times we find that the patient has brought an ultrasound with gallstones, and you don't even touch the patient and tell him to get admitted for surgery. So we are not spending enough time with the patients these days, and that is where the trust level goes down. So we should spend more time with the patients. We should select the patients properly. All patients need not be attended by all doctors. The practice of doing all types of major and minor surgeries in this hospital, as is written in the boards, is not wise these days. We should have a low threshold for second opinions. Whenever there is a problem or you anticipate a problem, take a second opinion, take third opinion, take a multidisciplinary opinion on a case, and have a low threshold for referral of patients. And whenever you refer it in time to a proper place in a proper manner. Then the most important thing is communication skills. This is one area where we lack the most. We are all aware that the medical curriculum in PG and UG levels, we are focusing only on the science of medicine. The art of medicine is ignored. And the most important aspect which is relevant in medical practice out of the art of medicine is communication skills. So we must inculcate good communication skills. We should spend time with the patients and resort to ethical practice. These are some of the points I think will help us in preventing litigation. Thank you.
Thank you, sir. Thank you, sir. Dr. Vashish sir, if he is there. I think he is not there. One point from my side, whenever we are taking medical indemnity insurance, kindly ensure that besides getting medical insurance for medical indemnity insurance for the doctor himself, also get medical indemnity insurance for your hospital also. Because as Dr. Jain has told us that vicarious liability, in case of vicarious liability, the hospital is also included in the claim process. So always take this medical indemnity for your hospitals also. And number two, all these companies which are giving competitive rates, they are having a clause of co-pay. That means up to certain amount, they'll say that up to certain amount in their finer prints, they will mention that up to certain point, like 1 lakh, 2 lakhs will be paid by the insured, and the amount exceeding that basic coverage will be paid by the company. So always read the fine prints which are supplied to you in your medical indemnity policy. Recently, I had such an experience with a company. I should not name that company, but recently I had such an experience with the company where 2 lakhs amount was referred as co-pay. So please also refer to the fine prints of the policy in your documents.
That we have removed, Dr. Pawan Goyal, as you
Yes.
talked to me and you just told me, so specifically we asked them.
Definitely,
Because
sir.
they were not having it, but we reiterate that it should not be there. So we had already removed it
Yes, sir. Yes.
from their offering. Okay.
And one more
One very
question from
important point. Once anyone who receives a notice of any form for an alleged medical negligence case, they should simultaneously inform their professional indemnity insurer and make them a party. The thing is, whenever somebody receives a notice, there's a panic situation, and we forget to report it to the insurance agency. So whatever notices or whatever any written this thing you receive against you or alleged medical negligence, you should always make the insurer the party to the case and inform right from the very beginning.
And sir, one more question from Dr. Ashish Jain.
Yes, sir.
In this era of digital recording and TPAs and panels,
Yes, sir.
all the TPAs and insurance companies ask us for the patient's medical records. So how to safeguard ourselves about the confidentiality of the documents of the patient to share with these companies or different panels? Is there any law points regarding that?
So definitely any document which is being shared, even if let's say we are using a digital record. So if we go to their agreements initially, so they mention that the confidentiality of the patient will be maintained, and even the TPA companies and all. So they cannot actually, we definitely, we lack somewhere in the digital. We cannot enter into that zone, and which is what is happening actually. We are using some digital software. It is being overtaken by somebody for reasons, and the data is being shared. So let's say we are using an iPad, then your data is stored on the Apple iCloud. And so they have got all the terms and conditions, and that should be fulfilled, whether it is a TPA or whether it is a digitalization of the records as well.
Sir, should we take the consent of the patient before sharing their records with the insurance company or anything?
Sir, basically, it depends on the purpose of this thing. Let's say a patient is admitted under a TPA. So definitely that consent is already there. It is implied that his documents and the medical records would be shared with the TPA for the further process. But yes, as a preventive measure, and it could be a double this thing, that double safety, you could take a consent from the patient that your records would be shared for the TPA and all the medical records. And so we can, it is a good process that we can share we can take a consent from the patient.
Especially in cases of TPA and insurance, I think we should include that one more line regarding the sharing of the records.
And if at all we have received it as a notice, if somebody wants it for legal purposes, then so definitely consent is there until unless the patient party has himself not given. If any third party without any official document or signature of the patient, authorization letter from the patient asks, then you're not supposed to give this to anybody.
So recently the advocates have been taken out from the ambit of this the Consumer Protection Act. Is there any chance that doctors will also be out of this Consumer Protection Act?
Sir, we already lost the chance. We already lost that chance almost a week before, 10 days before, when the Supreme Court put the last nail in the coffin of doctors being away from the consumer. And I think we should not really, it's a long way ahead, long journey ahead. First, we should set so many things in place, and maybe the whole culture now today we are here for medical legal. So definitely everyone is stressed out and bothered about the rising medical legal scenarios. So doctors it's not a situation now which was a decade before. Doctors were unaware of the rising medical legal litigations. So directly or indirectly, it is the consumer era, and it is the patient who ends up suffering. So sooner or later, even the courts have to understand that was the COVID situation wherein doctors had so many safeties like the Epidemic Act, Disaster Management Act, and any act of violence or anything. So we should take care of that. And I think the IMA Haryana should again reiterate to the higher up police officials about the Medicare Protection Act, which has been there since ages, more than 25 years. But when it comes to implication, when it comes to implementation, so it is not implied that, and it is simply told so that the patient was stressed at, and that's why he created a violence. And there should be no respite or no concession if any act of so-called violence has taken place with any of the doctors or the healthcare establishment. The whole IMA should come into place, which is what happens, and they should go to the police chief over there. And I also appeal to the IMA to ensure it has been done. We know about it, to ensure next that we have that. We should meet the commissioner of the police, our respective, and give them the Medical Protection Act, which is in place, and the police and we should paste it on OPDs.
Dr. Ashish, you are chairman of the medical legal cell of IMA
Yes, sir.
Haryana State.
Yes, sir.
So you please write or draft a good letter or our
Yes.
representation, which we will
Yes,
give
sir.
to Home Minister as well as to the DGP and everybody, and Home Secretary also. So please
Yes,
you
we'll
do
do so, sir.
you do this job, and we will thankful.
Yes, sir, we'll
And
do.
more thing,
Yes, sir.
we
Sure.
are having three of the speakers here: Dr. Pawan Rawal, Dr. Pawan Goyal, and you are Dr. Ashish. I will request again that please give a 2-page write-up of your talk so that we can publish it in the Haryana Medical Journal.
Sure,
So
sir.
Sure,
that,
sir. Sure, we'll do, sir.
yeah, please. Thank you. Thank you so much.
So I think there is no more questions. And now I would request Dr. Indra Mohan Rastogi to
Yeah, sir.
thank everybody.
One thing I would like to stress upon here, that every district, has got district in civil hospital. They have district negligence board. So as Dr. Ashish has just now said, that जो primary record है, primary evidence है, public safety है या protection है, अगर हम अपने केस को अगर वहां पे जो भी हॉस्पिटल के खिलाफ होता है या जहां पे भी होता है, हम अच्छे से अगर वहां डिफेंड करें तो आधी लड़ाई तो हम वहीं जीत जाते हैं. तो
Yes, sir.
मेरी एक यही रिक्वेस्ट है कि सभी लोग, सभी डिस्ट्रिक्ट के लोग, जो भी डिस्ट्रिक्ट हॉस्पिटल में जो नेग्लिजेंस बोर्ड है वहां पे जाएं, अपने केस के लिए अटेंड करें और उसको अगर जहां तक हो सकता है सेफ्टी के लिए प्रोटेक्ट भी करें अगर प्रॉपर पॉइंट्स है. अगर हम ये सोचे नहीं है मतलब वहां पे कुछ नहीं होता, क्योंकि अगर हम वहां पे अपने आप को ला पॉइंट्स में प्रूव कर पाते हैं, अच्छे पॉइंट्स दे देते हैं और रिकॉर्ड के हिसाब से प्रोटेक्ट कर पाते हैं, तो आई थिंक हम आधी लड़ाई तो वहीं जीत जाते हैं.
Yes, sir. Sir, I would like to add, as I told me in my slides, the landmark Jacob Matthew case. So it was told by the Supreme Court in way back in 2005, almost 20 years before, which clearly said that there should be a credible opinion, preferably of a government of the board. So that is why the board came into existence. And in 2019, again, the Honorable Supreme Court came with the same judgment that an opinion or any doctor can be said so can be proved negligent or negligent only after the credible expert opinion of the board, which constitutes 5 or 6 members. And even Punjab Haryana High Court way back in 2019 again said so. So that is how the district medical negligence boards were formed.
Yeah, that is what I'm saying. That is what I'm requesting, that everyone
Yes.
must attend all these district negligence board cases, and in time also with proper records, so that things can be, saved in the time.
Yes.
No, not only Dr. Rastogi, the person who is accused, but the IMA representative must attend all the
Yeah,
meetings.
that is, sir, वही कह रहा
Because
हूँ
we are fortunate enough that Haryana, we are having this system that there is a representation from IMA in District Medical Negligence Board. Otherwise, there are many states where it is there is no provision of representation from the IMA. So we must take advantage of that, and we must try that we should help our colleague Jain.
colleagues. Yeah, that is my request also. Right, sir. So anything else also?
Dr. Rastogi, please, your thanks notes.
Yeah. So, as Director CGP Haryana, I'm really thankful to our President, Dr. MP Jain sir, and Dr. Goyal sir for the coordinator for this, and Dr. Kavita, Chairman IMA Haryana, and of course, Speaker Ashish Jain, for highlighting, all these points for the common use and for the common members of the IMA, so that, we are aware of the things and we can take preventive measures in advance. Really thankful to all of you, and thank you very much.
Thank you, friends.
Thank you all and good night. Thank you.
Thank you.
Good night, sir.
Again, sir. Thank you, sir.
Good night, sir. Thank you, sir.
Good night,
Thank
sir.
you.
Good night.